Hello everyone, I am bhavik.narsana. I'm a partner with the law firm Katan and Co. and I'm in the corporate M&A and PE practice. I'm going to take you through some of the practical deal structuring issues, M&A and PE deal structuring issues from a foreign exchange law perspective. I will try to keep it as practical as possible. As we are all aware, FEMA has several gray areas and you know several views could be possible. Different views are definitely possible. I'm going to try and give you my views on some of these gray areas wherever possible and highlight those gray areas as well for you. Different law firms, lawyers have different views, and accordingly these are my personal views and do not necessarily represent my firm's view. Before undertaking any transaction, please seek your own legal advice. This is not a legal advice. I will, as a format, explain the concept very briefly and also take you through the issue and the gray area. This will obviously not be a very basic presentation, and it will. I'm assuming the audience will be fairly conversant with foreign exchange law concepts, and some of the topics in the presentation which are covered can be a part of a separate presentation altogether. However, I've tried to keep it very brief and short and try to make it interesting for you. Okay, so let's get started very quickly. What is the legal framework and what are the gray areas which arise because of the legal framework? So there is an act, rule regulations, rule circulars, notifications, master directions, FAQs, and FDI policies and press notes. The first gray area or the first question is that the master directions sometimes are inconsistent with the rules. So what prevails in that situation? Of course, the rules should prevail. Having said that, in the master directions were issued under the erstwhile FEMA regulations, which were repealed by the new NDI rules. So the question is whether the master directions issued then are still binding or not. As I understand, many AD banks still refer to the master directions, and accordingly, if there is any gray area around any issue, then it is always better to check with the AD bank and also understand RBI views on that gray area. So that is important, and I will take you through an instance where I've seen master directions being sort of different or inconsistent with the regulations. Press notes are binding? No, they are not binding. So whenever press notes come up, you please wait for the notification for amending the regulations, and then take a call. FAQs are binding or not? Answer is again no, but again it does represent RBI's views and understanding of the subject. The RBI website setting out FAQs itself says that in case of inconsistency, the regulations should be referred to and they will prevail. Minutes of conference, again this is not a very commonly known topic, but AD banks and RBI once in 4 months have a conference wherein AD banks ask their questions and RBI responds to those questions, and these question and answers are recorded in a form of minutes. I don't think that they are publicly available. You can always check the RBI website to find if to find those minutes, but you can always again check with the AD bank if they are available. But they do give insights on RBI's views on several gray areas which are asked by AD banks. Okay, quickly, concept wise, capital and current account transactions seems theoretical but very important from practical perspective, because as a concept, unless for capital account transactions are highly regulated, unless they are specifically provided for, one is not allowed to undertake that transaction. And current account is exactly the opposite, where you need to be restricted to, otherwise it's allowed automatically. The problem arises that the definition of capital account transactions is very broad, and it refers to all assets and transfers, assets and liabilities of the residents outside India, and assets and liabilities of non-residents in India. And current account refers to that definition of capital account and says that anything other than that is a current account. Generally understood that current account is related to trade and capital is more related to things like shares, loans, immovable property, etc. So what are the issues around this? So every time you face a question where something is not provided in FEMA, the first question that you need to answer is whether it's a capital account transaction or a current account transaction. So from a deal structuring perspective, some instances which can be sort of cited are exclusivity fee. For example, in a buyer is trying to bind the seller to not deal with the subject matter for a particular period of time and pays a certain fee. That fee is either adjusted with purchase consideration or forfeited by the seller if the transaction doesn't go through. Is this a capital account transaction or not? Because it's not provided for. So it seems that it's linked to shares, so therefore it should be treated as a capital account transaction requiring RBI approval. Similarly, non-compete fee as well. Because if there is any payment which is being made and separately for for non-compete fees, it will be treated as a capital account transaction requiring RBI approval. But again, if no payment is made or no specific amount is sort of mentioned for non-compete, one can say that there is no RBI approval requirement there. Goodwill, for example, with trademarks being transferred, whether that amounts to a capital account, current account, we understand it's a current account transaction. Damages is a matter of controversy, whether it's a capital account or not, and we will deal with it later in the presentation as to whether damages paid pursuant to a SPA, SSA transaction, whether they are treated as capital account, current account, and freely payable or not. The next concept is the FDI, FPI, FECI, and foreign investments. These again concepts are become important, and in the next slide I explain, but very quickly, the concept wise, FDI is investment in unlisted companies or more than 10% in listed companies. FPI is less than 10% in listed companies, and of course a same person cannot hold FDI and FPI investment at the same time in the same company. And FECI is again a very interesting route for investors, and foreign investment is a very important concept which has come in over the last 2-3 years, which again all the sectoral limits which are mentioned in the table are linked to foreign investment and not necessarily FDI only as it was earlier. So that is important, and I'll explain to you in the next slide as to why this assumes significance. Very quickly, FPI related provisions, individual limit is 10%, group individual and group both are 10%, and aggregate FPI is 24%. Breach, if there is a breach, then within 5 days you have to rectify it and bring it down to less than 10. But if you don't do it, then within 7 days you need to intimate the depository about such breach, and it will be classified as an FDI investment. With effect from 1st April, government has the rules provide that the limit of FPI will be automatically raised to, in all listed companies, will be raised to the sectoral limit unless before 31st March 2020 the company has passed a board and shareholder resolution reducing the limit of FPI to 24, 49 or 74%. So once the limit is increased, then you cannot decrease that limit. Again, interesting issues will arise because of this aspect, and I'll just take you through that issue later on in the next slide. The 49% without change, 49% in FPI investment without change of control to the non-residents, the sectoral conditions do not apply. So that's again very interesting example. Real estate, multi-brand, up to 49% FPI investment, sectoral conditions need not be complied with, and this was necessary to clarify because now, as I said, sectoral cap includes all investments, not just FDI and FPI. Prohibited sectors, again it is permitted up to 24%. So for example, a gambling company could have 24% FPI investments without any restriction. The other aspects of the FPI can invest, of course, in several securities like listed entities, warrants, preference shares. All these are available, and FPI cannot invest in LLPs. So quickly going through what the issues are. So can FPIs invest in unlisted companies? This is something that keeps coming up many times. The SEBI had also earlier this year in one of the informal guidances clarified that FPIs cannot invest in unlisted companies which are not going to be listed, because the investment is only permitted in listed companies or companies which are to be listed. So that is an important point to be noted while structuring. For any investment which is less than 10%, it is treated as FPI investment under FEMA, but under SEBI, are you required to register as an FPI or not? As I understand, it's a concept under FEMA. It does not necessarily require registration with SEBI. Having said that, I understand that some of the AD banks are taking a view that you also need to get a SEBI registration for that. So that is something that is important, because many PE investors investing in listed companies taking minority stake who should not ideally be required to register as FPI, but I think that hopefully the regulators should also clarify that aspect very quickly. The other interesting aspect is because of the fact that the sectoral limit now for FPIs have gone up, and because the companies if they have not passed the resolution before 31st March, the sectoral limit would be the limit for FPIs as well. So let's say a pharma company, 74% is the limit. Let's say the sectoral limit, so the FPIs take up to say 49%, 50% in a company, in a pharma listed company, and the promoter holding 50% wants to sell to another non-resident. He may not be able to sell without government approval, because then he would reach 74%, and accordingly there will be pose challenges. So that is one aspect that one needs to keep in mind when you are structuring deals and FPI investments are there in the company. FVCIs, again, as I said, is an interesting route. Limited sectors where they can invest. Several exemptions are provided, more flexibility is provided to FVCI investors while investing. So, for example, FVCIs cannot invest in can invest in OCPS, OCDs, and they can invest in limited sectors such as biotechnology, IT-related hardware, software, R&D in new chemical entity, dairy industry, poultry industry, etc. And under SEBI, there's a negative list where they cannot invest in NBFCs other than CIC, AFCs, and IFCs registered with SEBI, with RBI, sorry. Gold financing activities not permitted under industrial policy, any other things which are specified by SEBI. FVCI, again, these are the investment conditions which need to be complied with by FVCI. So that is something that could be looked into as a disadvantage. But there are some other advantages like FEMA pricing do not apply to FVCI, so that really gives a lot of flexibility for FVCIs to structure their investments. Takeover regulations, exemptions are provided for sale to promoter with more than 25%. IPO lock-in is not applicable to such FVCIs on listing, and FVCIs again cannot invest in LLPs. The other interesting concept is that in listed companies, it seems that secondary acquisition is not possible on stock exchange for FVCIs because that is not specifically provided for in SEBI and FEMA regulations. Another interesting concept and the recent controversy around investment from China, and the government came up with the rules to stop the opportunistic takeover and acquisition by Chinese firms of Indian entities. So several gray areas have come up and several difficulties have come up, which are all unanswered questions, and I'll just take you through some of them. There are several more probably which are there. Very quickly, beneficial ownership test. Now this is a test where if a foreign investor is investing in India, he should not have any direct indirect Chinese investment in the foreign investor, so such that there is no indirect foreign investment that happens in India. So question is, what is that indirect ownership, or as you call it, the beneficial ownership test? Companies Act of course provides that 10% threshold. Prevention of Money Laundering Act provides 25% threshold. Different AD banks are taking different views. Technically today, if you ask any single 1% investment also is covered of the Chinese investor in the foreign investor. The next point is again very interesting, and because of this beneficial ownership test, it leads to this absurdity that let's say a company is listed abroad and that listed company has some Chinese investment in it, then that listed company would also get restricted from making investment under the automatic route, and it will need government approval. FPI, FPCI, AIFs, LLPs, all these ideally should not be covered technically because the change has come into the FDI part of the regulations, not these. But there are arguments which are available, which one can argue to say that these are also covered under the prohibition. Hopefully the RBI should clarify that aspect. Hong Kong, Taiwan, again different AD banks taking different views. Hopefully the regulator clarifies whether investments from Hong Kong, Taiwan is permissible or not under automatic route. Investment in existing wholly owned subsidiary, again this is not an opportunistic takeover or an acquisition. It is only in further investment in an existing company, so ideally should not be covered. However, presently the way it's drafted, it is prohibited, and hopefully the regulation should clarify that aspect. ESOPs, again, to an Indian person situated in China and is employed with an Indian company, but because of the way they have drafted the regulations, even an Indian situated in China will be prohibited from getting ESOP. Debt conversion into equity, again, will be treated as a foreign investment, and the FDI, and therefore it will be prohibited. Pledge enforcement, again, where the buyer is directly indirectly a Chinese, government approval route will be applicable. CCPS CCD conversion should ideally not be applicable because there is no further FDI which is coming in, it's a mere conversion. Downstream investment, which is an Indian company with Chinese investors or Chinese parent holdings, these again would be covered because they will be treated as indirect foreign investment by Chinese investors. and the gray area is that if there's a business or an asset acquisition by a company which is owned directly or indirectly by Chinese, should technically not be covered under these regulations. Having said that, it may be treated as a violation of the spirit of the regulations, but again, that's not clarified, so hopefully RBI should clarify that aspect. Partly paid up rights issue and bonus, again, these are all aspects which probably are prohibited or under government approval route. The other recent interesting change that had come about in the FEMA regulations, which can give rise to structuring issues, is rights issue. Earlier, the rights issue pricing could be fixed by the unlisted company. As per the same, it has to be the same price as the Indian, price offered to the Indian shareholders. And similarly, even under the SEBI regulations, it refers to the company and the lead banker fixing the price. Now, there was no concept of FMV applicable there. So even in renunciation, the same rules sort of applied. However, this change which has come now, where a resident renouncing his rights to a non-resident, pricing guidelines needs to be applied. So unlisted company, it's clear that FMV pricing should be sort of followed. But for listed companies, there seems to be an issue that because the rights issue still, FSAB regulations to provide for rights issue, and again the pricing flexibility is available even in renunciation. So I'm not sure that if that is the intention of RBI, but again, if the intention is otherwise to sort of apply the FMV even for listed companies, then that should be clarified by RBI. NR to NR renunciation again should not be covered under this amendment. Both if there is any shares which are sort of remaining after the rights issue is subscribed to by all the existing shareholders and the board needs to dispose of, then again this should not be treated as a renunciation, and the same price should ideally be applicable even to the subscriber after that. FOCC acquiring from a resident, renunciation should not be covered here, although one can argue from a spirit perspective that should also be covered over there. So again, hopefully the regulations and the regulators do cover or clarify that aspect. Now again, another concept or a question that keeps coming to me from various clients is, how do I issue shares for free to a non-resident? So what are the ways? So there are a few ways in which you could issue shares for free. One is swap of shares, where there is no cash being sort of exchanged, only shares being exchanged. The next is more interesting, is it's against any dues legally payable by the company to the investor. So if the company has received any goods or services and it needs to pay some money to the foreigner, the company could also issue shares in that case, so that is permitted. Bonus shares is fairly simple, we are all aware. Import of goods again is permitted, so that is but anything other than second-hand machinery. Pre-incorporation expenses up to 100% is in a 100% permitted sector, automatic sector, maximum 5% or 50,000 plus. Of course, reporting requirements are there, and there's a gift from NR to NR as possible, so there is no cash exchange of cash there, and non-resident to a resident. The only interesting issue that comes up is in case of swap. It seems that the regulations provide for issue of shares and swap permitted, but it does not deal with secondary. So it seems that swap where both the legs are secondary is a bit of a gray area. So always good to take clarification from RBI on this aspect. What are the equity instruments? Equity shares, CCPS, CCDs, partly paid shares, and share warrants. A couple of issues around the instruments. One is whether can you secure CCDs? The answer is no, because it's a capital account transaction, not specifically permitted, so it should not be permitted. CCDs may not be able to be secured. Can unlisted company issue warrants? The question arises because the regulations say that share warrants need to be issued as per the SEBI guidelines, and they are not applicable to unlisted companies. So whilst I think it's always better to, because this is sort of not clear, it's better that you take clarification if an unlisted company is issuing share warrants. Unlisted company pricing, again it's FMV. I won't go too much into detail. Pricing of listed companies. Now this is where I will come back to my original point, which I said that there is a inconsistency between master directions and the regulations, and this was again the regulations as the erstwhile regulations, and so quickly, in case of listed companies, the pricing for issue is cannot be undertaken at a price which is less than the price worked out as per the SEBI guidelines, and the relevant date is linked to the shareholders meeting here. Similarly, the acquisition by NR, so when NR is acquiring shares, again that price cannot be less than the price worked out as per the SEBI guidelines or the pref allotment guidelines pricing. And the most important part is the relevant date here, that it is linked to the shareholders meeting. And the next one is the controversial one, which refers to the price being not less than, again similarly, the SEBI guidelines or pref allotment guidelines, but it links to the relevant date which is on the sale of purchase or sale of security. So therefore the problem that arises is that when you entering into an agreement, can you say that the price which you write in the agreement is the fixed price and it's a SEBI FEMA compliant price or not? The answer is not necessarily yes or no, because it depends on the date of price of actual purchase and sale, whether the price will be compliant with FEMA or not, because the relevant date is actual date of sale and purchase, which is why many a times where there's a long time period between signing and closing and the price could fluctuate substantially in a listed company, parties sometimes prefer to go to RBI and get an approval upfront for such price. RBI of course will look at it on a case to case basis, and and that poses a real serious challenge to structuring transactions whenever a non-resident is selling to a resident. Now interesting issue from a master direction perspective is because master direction has actually referred to the relevant date for all transfers between resident and non-resident, not just transfer by resident as is provided in the rules. So therefore the question arises that even in the second bullet point on top in the slide, where you're saying acquiring NR is acquiring, the relevant date is provided as date linked to the shareholders meeting. The safe view is, I think, to go with the regulations, of course, and master directions would not necessarily overrule or prevail over the rules. Escrow pre-closing 6-month period is permitted. Can offshore escrow be permitted or not? The answer is no. Can an advisor hold shares or cash in escrow pre-closing? Answer is no. It has to be AD bank only. Okay, the next concept is deferred consideration, escrow and indemnity. So FEMA does permit in a transaction that 25% of the consideration could be held back, and it could also be kept in an escrow, but the term period is maximum of 18 months. The indemnity obligations also sort of permitted to be paid, so 25% of the consideration could also be paid by way of indemnity, but it has to be within the 18-month period. Total consideration ultimately needs to be compliant with pricing guidelines, and of course from time to time whenever payments are made, FCTRS needs to be filed. And of course these are all secondary related transactions only, not primary. In primary issuance it is not permitted. Several issues arise. First of all, the public companies anyways cannot undertake deferred consideration because of the Securities Contract Regulation Act, which prohibits deferred payment. It is a T+1 spot delivery requirement which has to be complied with. So this is only applicable and beneficial to private companies, not to public companies. Can indemnity payments being made in a transaction involving deferred consideration? The answer is it should be yes, because this does not, so long as you are meeting the 25% threshold limit and the 18-month requirement, it should be fine. Earn out is possible, pre or post completion purchase price adjustment is possible. Well, answer is yes and no, depending on AD banks. We have seen some AD banks permitting purchase price adjustments going forward, and some AD banks not permitting. So it's always better to check with your AD bank involved whether you'll be able to do this or not, because it's a very important concept. Every M&A deal or a lot of M&A deals would have some sort of adjustments in their transaction. So again, that needs to be checked. Is RBI approval required at the time of execution of the agreement itself? Well, the answer should be no, because I'm just entering into an agreement, I'm not making any payment, so there should be no violation over there. And that's also the practice, as I see that we have indemnity clauses in the agreement which provide for obligation of more than 25% and beyond 18 months as well. Okay, another very controversial assured return point, where investors are because RBI views that if the investor invests with a minimum guarantee of returns, they treat it as a debt, and therefore they do not like it, and they do not allow it. So what are there any workarounds as far as exit and assured returns is concerned. So can agreements, again going back to the same question, can agreements mention that foreign investor will get assured return subject to applicable laws? Again, here you can argue to say that, look, I'm anyways saying subject to applicable law, so I should be permitted to write, because if tomorrow the law opens up, then I should be able to get the benefit of this provision. But there are views available. In fact, in practice, we have also seen RBI in some cases asking parties to delete the clause in the agreement, not just and treating it as a violation. So it's better not to have this clause in the agreement at all. Can default coupons on CCDs be used to provide minimum guarantee? In such cases, what happens is that you could invest in a CCD, and is guaranteed some sort of interest, and interest, there is no prohibition and provision on how much interest can be paid. You can structure your transaction whereby after 3, 4, 5 years, the obligation of the company is contractual under the debenture to pay certain interest, which guarantees a minimum, at least the capital protection. Having said that, it needs to be drafted and structured carefully. It should not be seen as an assured return over there. So that is an interesting aspect, and of course tax and accounting treatment will also need to be looked into. Can CCDs and CCPs provide for conversion to a higher number of shares? Yes, that can be done, but if the use is limited, it cannot be more than the price cannot be less than the FMV at the time of issuance of the CCD CCPS ideally, and so that may not necessarily be possible. Again, these are all options that I'm sort of explaining. These are not necessarily 100% perfect situations, but these are only workarounds to give something is better than nothing situation. Whether returns can be capped, so can you say that the investor will not get more than X amount in case of in the future? I mean, let's say for example there's a clause which says that the company promoter will buy back but not more than X amount. The answer is yes, you can, because this is not specifically prohibited. Of course, it has to meet with the pricing regulations at that point in time, but ideally it should not be a problem, because it needs to be less than the FMV when the Indian is buying from a non-resident. So this should probably not be a problem. Whether damages, again, now this is going to the next slide along with this point. Can you say in an agreement that if an event happens, or if a particular condition is fulfilled, then the company is required to pay damages to the investor? So for example, let's say the company doesn't achieve X amount or does not start its business within a particular time period, or it does not achieve a particular sales, then the company will pay damages to the investor. Can you do something like this? Well, it has not been fully tested, but yes, some courts, especially Delhi High Court, has seen this position, and Delhi High Court, and where there has been an award which has come up before the court for an award which has granted damages to the foreign investor, and the Indian obviously has taken objections, saying it's nothing but violation of FEMA, assured return, against public policy. Courts have taken views. The Delhi High Court has taken a view that, look, just because it is some provision of FEMA is violated does not necessarily mean that it's a violation of public policy, and accordingly courts have honored or sort of upheld the contractual arrangements and required Indian parties to comply. Having said that, these are all Delhi High Court cases and not necessarily 100% binding, but they definitely provide some guidance. What one can learn from these cases is that you could think of drafting your contract in a manner where damages are being paid pursuant to contractual arrangements, and try and not make it look like it's being paid pursuant to a capital account transaction. These of course need to be structured in for each case, but they definitely provide a very important structuring, and can save an investor and get some benefit for the investor if the contract is drafted well. Optionality clauses, again, the issue is basically whether you can have optionality clauses in secondary deals or not, because the regulations only talk about optionality clauses at the time of issue of shares, not necessarily transfer of shares. It's a gray area, but as I understand in practice, we see optionality clauses even in secondary deals, but it would be good if the regulator comes up with certain clarification on this point. Okay, so upside sharing. Now, upside sharing is a concept, very quickly, is where the investor says that, look, if I make more than 20% of my investment, then I will share X amount with you as a promoter. Now question is, when the investor has to share that money with the Indian promoter, how will the Indian promoter get the money and what will be the transaction? Again, let's go back to the original concept of whether it's a capital account transaction or a current account transaction. Because it is linked to actually share purchase and the share value, it can easily be argued that it's a capital account transaction and should be specifically permitted, which it is not, and therefore it would require RBI approval. So are there any alternative options or workarounds to achieve this objective? The answer is there is no 100% perfect alternative route for this. Some of the things which can be sort of considered is that you could have a separate class of shares being issued to the promoter. Of course, it involves some cash being paid by the promoter to the company, but it could be a separate class of shares, and it involves, at the relevant time, either a dividend could be paid or a buyback of shares could be considered. Of course, tax issues will need to be considered and number crunching will have to be done at the relevant point in time. Again, as I said, this is not a 100% perfect solution, but at least some workaround on option. Can OCDs be issued to the promoters, and the conversion ratio is provided such that the benefit of the upside is given to the promoters through the additional shares that are being issued. All possible, but again, valuation both under Companies Act and will also be applicable, and at the relevant point in time it may not be 100% certain as to how much valuation will be sort of needed to be passed on to the promoters. But again, there's something better than nothing against that situation. In listed companies, of course, you need board and shareholder approval, and in majority of minority is required under the listing regulations for upside sharing. Anti-dilution and transfer restrictions, very common to see in any shareholders agreements where investor has an anti-dilution, where there is any future down round where the shares are issued at a price less than the price issued to the investor, then the company is required to issue such additional number of shares such that the average price is the lower price at which the share company is planning to issue the shares. How is it enforceable? Because you have FEMA, the investor has to pay money and fair value to get those shares. So how would you be able to do it? Again, no 100% perfect solution available, but some workaround structures which one can consider. Of course, not very market to see these in the agreements, but if there's an investor who is very particular about ensuring the enforceability of anti-dilution, then this is something that they can. So these are some of the options that they can consider. A separate class of shares are issued to the investor, and a dividend is issued such that the economic benefit of the down round is passed on to the investor. Conditional payment on CCDs and CCPs. Again, interest could be paid on the condition that shares are issued at a lesser price. These are all these are contractual arrangements, and can be considered. Nominating an Indian to subscribe again is standard, but how much it is sort of practiced is not clear. Damages, again, can you say that the company will pay damages to the investor if a down round happens? And enforceability, again, not tested, but definitely something that the investor could explore and put in a clause. Can the conversion ratio be adjusted? Of course, that needs RBI approval, so that may not necessarily work for. Rights issue, again, if there's a renunciation, then pricing guidelines come into play. But can you structure the rights issue in such a way that the investor gets the benefit? And again, at the first instance, the investor gets the price which is a lower price than the fair market value, because it's a rights issue, and the Indian partner does not subscribe to those shares. Then in that case, the benefit could be passed on. But again, it's very difficult to structure this in a transaction. Transfer restrictions like tag along, ROFO. Again, these are agreements between residents and non-residents. If a non-resident is transferring to another non-resident at a price which may not necessarily meet the FEMA price, then the Indian party may not be able to participate, or vice versa. So therefore, those are all enforceability issues which need to be kept in mind. Again, agreements do not get complicated by trying to provide various methodologies, but this is something that we should just be aware of. Again, can you use damages in such situations where the investor or the Indian promoter not being able to get the benefit of a tag drag, and there are contractual payments by way of damages is required to be paid? Again, not 100% perfect, but at least some option, something for the parties to consider. Downstream investment, these are the three methods of sort of how you calculate foreign indirect foreign investments in an Indian company. So an Indian company owned or controlled by a foreigner is an FOCC, which is foreign owned and controlled, and any investment made by the FOCC is treated as a downstream investment. Now, what are the issues that arise at the practically from a pricing guidelines and a reporting perspective? The regulations provide for a situation where the investor, foreign owned and controlled company FOCC, is transferring the shares. The regulations do not provide for a situation where FOCC is buying the shares. So it's only in a situation where, let's say, so therefore the gray area or the difficulties arise where FOCC is buying from a resident or FOCC is buying from a non-resident, whether pricing guidelines apply or not, and whether reporting requirements are there or not. To be safe, it is better to take a view that yes, they do apply and comply with those pricing guidelines. And of course, so these are just a couple of issues relating to pricing guidelines and reporting requirements. There are several other issues, and I've also written an article on downstream investments. So what are those issues? So can you have a deferred consideration, escrow, purchase of shares on stock exchange, etc.? These are all restrictions applicable to non-residents. Are they also applicable on FOCC? The argument is that FOCC is a fictional non-resident for only specific purpose, and all these restrictions do not necessarily apply to an FOCC, which normally otherwise would apply to a non-resident. But the next question, which is whether the FOCCs can invest in OCDs and OCPS, is again a big gray area, because whilst you may argue to say that OCPS and OCDs investment one at the time of investing in these securities, it is not a downstream investment as defined under the regulations, but at the time of conversion it will definitely be a downstream investment. So then are you going to be compliant with pricing at the relevant point in time? Are you going to be compliant with how the money is being brought into the company at that relevant point in time? These are all gray areas, and it will always be better to get RBI clarification on these aspects before OCPS, OCDs are invested in by FOCCs. Again, this is my view. I have seen law firms taking different views, so it's always better to be safe, in my view. Can FOCCs acquire 100% in a regulated sector? So yes, whether an FOCC is acquiring 100% in a pharma company, whether that is fine or not, it seems that because it will be treated as a foreign investment. But because of the third structure, and I'll just take you through again, because if you look at the third structure here, which is offshore companies holding 51 and in the Indian company is holding 49%, it's an FOCC, and in the OPCO is 100%, is possible that in that situation that the FDI in the OPCO is treated as 51%, and accordingly even in let's say if the OPCO was pharma company here, that is also possible. Okay, the next interesting point is if the regulations provide that if your foreign investor specifies a particular audit firm having an international network for audit for an Indian investee company, then the audit of such investee company should be carried out as or joint audit, where one of the auditors should not be a part of the same network. Now, this is very common. Every shareholders agreement you will have a provision that, so for example, one of the big four will be an auditor appointed by the investee company. Now, it could give sort of some support to Indian auditors. Probably this change has been made, which of course it means that if they specify one of the big fours, then they will have to have some other auditor also, and obviously they may not go for another big four from a cost viability perspective, so they may go for an Indian auditor. So there is a restriction, there is this provision that has been introduced. So what are the workarounds? Can you say in your shareholders agreement that without specifying an auditor, can you say that it will be a joint appointment by the Indian and a non-resident? It seems that should be fine, because it does not necessarily specify an auditor. Again, can the non-resident have a reserved matter on appointment of auditor? That's again another option that is available. Again, the next point is on compounding, and compounding is a procedural kind of requirement, but it becomes very important in some cases, especially whenever we do deals, we are doing a diligence, we come across a situation where the company has not filed any form or there's any other violation, and the sort of the investor or the acquirer asks what is the penalty or consequence or the quantified amount which is possible. So theoretically, the amount could go up to 300 times the amount involved, but that's not necessarily the norm. So what RBI has done over the last few years is they've come up with this compounding guidelines where they've identified certain offenses which can be compounded and certain offenses which cannot be compounded, and provided for as a guidance an amount which could be levied. So very quickly, those offenses are like violation of pricing guidelines, or not refunding share application money, or not filing forms. These are all compoundable ones. Not compoundable ones are those which are similar offenses already been sort of compounded in the last within the last 3 years, or the transactions which require government approval, or there's a money laundering kind of serious offense, terror financing, or where ED has already adjudicated an offense, then those offense cannot be compounded. Quantum of the fine and penalty imposed and contravention will, of course, it depends on the contravention and the period of delay and period of offense. The RBI has also introduced a late submission fee for delay in reporting foreign investment transactions, and percentage of the LSF, which is the late submission fee, is doubled every 12 months. Very quickly, what is the amount? What could be the amounts that they have mentioned is that up to 10 million they have said that is 0.05% as the late submission fee, and more than 10 million is 0.15 million. But in each case, they have provided a cap of 1 million and 10 million, or 300%, whichever is lower. So that's interesting, because at least when you now that helps in deal structuring, and one can understand what is the amount involved. If if compounding is not preferred, then adjudication is required to be done, and accordingly one will have to go through the entire adjudication proceedings. So with this, I think I come to the end of a very quick presentation. I hope you found it relevant and useful. If you have any queries, please feel free to write to me on my official email ID, bhavik.narsana@khetanco.com. I'll try and revert to you at the earliest. Thank you so much.